Debt negotiation strategies for New Jersey small business owners. Running a small business in New Jersey often involves juggling customer demands, supplier invoices, credit cards, and merchant cash advances. When revenues dip and payments mount, those pressures can quickly threaten both the company and its owners. High-interest merchant cash advances, past-due supplier invoices, and rising credit card balances can make even a resilient entrepreneur feel overwhelmed. Once a creditor secures a judgment lien, business assets and even personal property may be at risk. Before assuming that bankruptcy is the only option, speaking with an experienced bankruptcy lawyer who can assess the situation and identify strategic alternatives to protect business and personal assets. The guide explains that debt negotiation can offer a smarter and less disruptive path than bankruptcy. A skilled debt negotiations attorney can evaluate debts, challenge questionable claims, and negotiate settlements that reduce balances or restructure payment terms. With the right guidance, business owners can regain control of their finances and put the company on a path to recovery. Understanding the legal framework in New Jersey is vital. The state's statute of limitations for most written contracts is 6 years, while debts related to the sale of goods have a 4-year limit. If the statute has expired and the defense is raised promptly in court, it can bar a collection lawsuit. Pre-negotiation audit. Effective negotiation begins with a detailed audit. Business owners are urged to shift their mindset from panic to control and to build an unassailable understanding of their financial reality. The first step is to review the statement of cash flows, breaking it into operating activities, investing activities, and financing activities. This evaluation helps determine the amount of disposable cash remaining after essential expenses, which becomes the realistic repayment plan, and prevents agreeing to unsustainable terms. Entrepreneurs should assemble a financial dossier that includes recent tax returns, profit and loss statements, updated balance sheets, loan agreements, leases, and a schedule of debts listing each creditor, balance, interest rate, and payment status. Presenting a professional package signals seriousness and allows the lawyer or the owner to base offers on verified numbers, not emotion. A legal and financial audit should follow. An attorney reviews contracts and account statements to confirm charges are legitimate and that the debt is still collectible. Verifying validity and ensuring the statute of limitations has not expired shifts the tone from, "Please help me," to a confident proposal based on discrepancies identified. General negotiation strategies. Negotiation is both psychological and financial. Creditors often prefer settlement because lawsuits are expensive and risky, particularly if a debtor might file for bankruptcy. Several tactics can strengthen a debtor's position. Be professional and avoid rudeness. Maintain composure because creditors respond better to courteous requests. Be truthful and concise about financial hardship. Document every conversation by recording names, dates, times, and key details to protect against later disputes. Finally, insist on a written agreement that includes the full legal names of the parties, any lawsuit reference number, the settlement amount, payment schedule, default remedies, and signatures. A written agreement is the only legal safeguard against disputes or surprise claims. Lump sum versus payment plan. Negotiators must decide whether to offer a lump sum settlement or a payment plan. A lump sum settlement pays a single, reduced amount, often 30 to 50% of the original debt, to satisfy the balance. Creditors prefer this option because it provides immediate cash and closes the account quickly. When a lump sum is not possible, a payment plan proposes repayment of the full balance or a slightly reduced amount over a longer period. While creditors may be less enthusiastic, they may agree if the plan appears reasonable and sustainable. Business owners should beware of stipulated judgment clauses that appear in some payment plans. Signing such an agreement allows the creditor to obtain a judgment against the debtor. Missing a single payment can let the creditor enforce the judgment immediately through levies or garnishments. Therefore, an attorney should review any settlement agreement resolving a pending lawsuit. Merchant cash advances and confession of judgment ban. Merchant cash advances, MCAs, offer fast capital by purchasing a portion of a company's future accounts receivable. They are deliberately structured as sales rather than loans to avoid lending and usury laws. Many contracts include a reconciliation clause allowing payment adjustments when revenue drops. Business owners should promptly request reconciliation and document any refusal. A refusal may indicate that the agreement functions more like a loan, which could make it unenforceable under New Jersey's criminal usury laws. New Jersey's Legal Shield. NJSA 2A, 16-9.1. This statute prohibits providers of business financing from including a confession of judgment in contracts and declares any such provision invalid and unenforceable. If a contract contains a confession of judgment, an attorney can use the law to challenge the agreement and sometimes invalidate the entire contract. This legal protection can turn a position of weakness into leverage and may expose the lender to civil penalties. Secured debt and SBA loans. Secured debts such as SBA loans and commercial mortgages require a precise strategy. SBA programs differ. 7A. Loans are issued by private lenders and guaranteed by the SBA, while economic injury disaster loans, EIDL, are made directly by the SBA. Both often include personal guarantees, meaning default can trigger collection against business and personal assets, including the owner's home. Negotiating with the SBA is possible through an offer in compromise, but this formal process demands detailed financial documentation and legal advocacy. A case in which a legal team challenged 2 lawsuits and negotiated with the lending bank, the SBA, and the U.S. Treasury. After 2 years, the entire $1.2 million debt was forgiven, personal guarantors were released, and the mortgages were discharged. This outcome shows that even large SBA defaults can be resolved when a coordinated strategy is pursued. Commercial loan defaults, personal guarantees, and bankruptcy. Business owners often believe that New Jersey's foreclosure first rule forces banks to foreclose on commercial property before suing the business owner. However, an exception under NJSA 2A, 50-2.3 allows lenders to bypass foreclosure and sue directly on the promissory note. Early legal intervention is essential. An attorney should review loan documents to determine whether the exception applies and develop defenses that preserve leverage and may prevent a personal judgment. Many owners form LLCs or S corporations believing that the corporate veil protects them from personal liability, but lenders often require a personal guarantee. By signing a personal guarantee, the owner voluntarily waives corporate protection and promises to repay the debt if the company cannot. When default occurs, creditors can sue both the company and the guarantor, putting the guarantor's home, savings, and investments at risk. Filing a business Chapter 7 bankruptcy does not discharge corporate debts and does not remove personal liability under a personal guarantee. The correct strategy may involve the owner filing a personal Chapter 7 to discharge personal liability or a Chapter 13 to restructure the debt into a 3 to 5 year payment plan. Such coordinated filings require guidance from an attorney who understands both business and bankruptcy law. Taking control of your business debt does not have to mark the end of your business. With the right legal strategy, it can be the beginning of a more stable and sustainable future. Whether the challenge involves merchant cash advances, SBA loans, or mounting commercial debt, the key is to act before creditors seize control. Strategic negotiation backed by a detailed financial review and legal guidance can protect your assets and preserve the business you have worked so hard to build. Professional help is available for New Jersey small business owners facing overwhelming debt. A knowledgeable lawyer can guide you through every step of the negotiation process, ensuring that your rights are protected and your options fully explored. To discuss your case and develop a customized strategy for financial recovery, contact Straffi and Straffi Attorneys at Law. Their office is located at 670 Commons Way, Toms River, New Jersey, 08755, and they can be reached at 732-341-3800.